Opening statements. One thing that you have to keep in mind is that in our criminal justice system here in New York, it's different in other states. The prosecutor starts and the prosecutor ends. The first thing that you hear is the DA. The last thing that you hear is the DA.
Why is that? And also go into the fact that opening statement is not evidence.
Yeah. Well, why is that? I don't fucking know. Now I'm telling you this. Why is that? Is because the DA has the burden.
Yes.
Right. But that's what they. In reality, you know, it is that. And in some states, you have the possibility, you know, to finish. In summation, they go DA first, then the defense, and then they have a little time for rebuttal. So it's just it varies by state. Okay. Virginia is one of the states that allows a rebuttal.
I don't know shit in Virginia.
No, Virginia.
I don't know.
Yeah, that's what I mean.
That's what
I pointed to. Hand to you. Virginia allows a rebuttal by the DA, but the defense goes second.
A rebuttal to the defense's argument. Right?
But that's in every jurisdiction the DA goes last because they have their burden, their job.
So let's just talk New York. Prosecutor does their opening statement. We've already established not evidence, right?
It's not
there
evidence.
Are certain elements that opening is required to have as a prosecutor that doesn't actually correlate to what a defense attorney has to say.
Yeah.
Defense attorney has no responsibility to say anything in their opening. They don't even have to do an opening.
But
the prosecutor, if they're going to do it, the prosecutor has to do an opening, and they also have to establish certain things, right? They have to establish the fact that the crime was in the jurisdiction, the time, the date.
I mean, in reality,
they have to say the burden, right? I believe.
Yeah. Well, in I mean, in reality, the DA is going to tell you in opening statement usually what they plan to prove in the case, and that's why defense attorneys should pay attention to opening statement because they give you a map of what they're going to prove, and usually, also, you know, DAs point a finger, say this person did it, opening statement, and you can use that against them a lot of times. But defense attorneys don't need to do that because, again, you say that the job is not on ours. The job is on them to do it and to prove a case beyond a reasonable doubt. And they have to tell you, you know, it was committed in Queens, what they did, and all of that. And then it's up to us to either respond if we want to or not, right? The defense attorney, usually, I tell people, you know, do an opening statement, but do it very, you know, it's just kind of like a blanket. Don't go in depth as to, you know, everything else. Just like
and why?
Statement. Because you don't want to commit to something that you are going to do, and because you have nothing to prove. If you commit too much, then the jury is expecting you to do something that you don't need to do. And what you have to think about is that in a case, in a criminal case, the defense attorney doesn't have to prove or disprove anything.
Why is that?
Is because of the standard in our law. The standard is beyond a reasonable doubt. The prosecution has a job to bring forth the evidence and prove to you the case. You said it, beyond a reasonable doubt. The defense attorney, it's hard to explain it.
Yes.
There's no
one standard definition.
There's no one standard. You know, I mean, what the judge will tell you is that a reasonable doubt can come from low quality evidence as well as the lack of evidence.
Okay.
So, and that's actually, in my opinion, the most defined that we will get this term reasonable doubt. Because if you have any doubt based on the low quality of the evidence that is presented to you, as well as the lack of evidence, you know, meaning was there surveillance? Was it this? Did the cops go to the scene?
Where was this witness?
Exactly.
That witness was missing.
If you have any doubt based on that, then that's a reasonable doubt.
Now, as a defense attorney or even a prosecutor, can you get in trouble or be told not to speak about the term reasonable doubt in any way, shape, or form? Like, is there a way you can and cannot talk about it?
Yes, I mean, first of all, during opening statements, you know, you kind of have, like I said, you have a little blanket policy of just, you know, saying what the case is about without really getting in depth. The judge will, it differs. Judges sometimes do, sometimes don't, but don't try to explain the law that the judge is going to give them. That's what you're going to get every single time. I tend to do that a lot because I want to educate the jury that this is not like the real world. This room is this room. When you get outside, it's when you get outside. It's a completely different deal. So you know, I tend to try to explain more so they can get it. But you're right, you can get it. You can get in a lot of trouble. So it depends on your defense. I think I think people should think of a case in the terms of explaining to a jury the principles of law. That's what I call them, the principles of law. Beyond a reasonable doubt, burden of proof, low quality and quality evidence. I call the fourth one I do is speculation, because the judge will tell you cannot speculate, you cannot guess, you cannot fill any holes for the district attorney. And then you go into what you said. For example, your defense. What's your defense in a DWI? This person was not intoxicated. Margin of error. Machines make mistakes. What's your defense in a self-defense case? Do you have a right to defend yourself? Yes, you do. When do you have it? So that's the difference between both things that you tackle voir dire. And I think that's what you were asking me. In terms
Okay,
of
so now let's get back. No, go ahead. I apologize.
So, but like, for people to understand, like, why wouldn't a defense attorney then put on a case? Like, why wouldn't you? Like, I know it's the prosecution's burden and they go first, but like, why wouldn't a defense attorney not say anything or put on a case? Like, for those jurors who sit there and it's like, I was waiting for you to talk and say this and say that. Why won't they do it?
Because they burden shift. I mean,
they do, and
do.
that's why it's so important to select a jury that knows and is educated enough to know that in our standard of law, we have what is called the presumption of innocence. Right?
Okay,
And I'm going to tell you, it's a hard term to actually put into mind, but you are presumed innocent, right? And that is the reason why when you arraign, you plead no guilty. When you get arraigned on an indictment, you plead no guilty. And what people need to understand is the person sitting here to my left, for example, if I'm a defense attorney, they've been going through a lot of waves, as I call it, and they've been maintaining their not guilty all throughout. So as they sit at that table, they are presumed innocent. And if the people want to change that, right? If the DA wants to change that, they have to provide evidence and proof. And that is why, is because our system of law is built like that. It's built to protect an innocent person from going to jail, right? And that's what we've heard time and time again, right?
But then
I actually think there's a good story that explains this point, right?
Why?
It's something that you would do in jury selection, which is this kind of concept that you have a child, a parent, every morning this child wakes up, doesn't clean his bed, right? Comes downstairs to have breakfast before he goes to school. Mom goes upstairs after the child goes to school. The bed is unclean. First time, what the fuck? Clean your bed. Second time, what the fuck? Cleans your bed, right? Third time, kid gets it. Kid cleans his bed, right? Cleans his bed, fixes it. Goes downstairs, has breakfast. Their dog.
I talk about the dog.
The dog goes into the bed, fucks it up, right? Now the kid, first time, got pressed by the parent. Let's say the first time the kid says, "Oh, I cleaned it," but the mom knows she didn't. He goes, "All right, I didn't clean it." Second time, same shit. Like, right? Because kids sometimes lie about bullshit, right? The third time, when he legitimately cleaned it, and he doesn't even know how the bed got fucked up because he's not even that smart. The question becomes, how does that kid in that moment prove his innocence? Is his, what is it? You test too much. Like, what is the phrase? Like,
but that's the thing. You don't have to prove your innocence. That's
what I'm saying,
you have to explain to the jury. I think that's
legally.
That's what I mean when they come outside.
But sometimes you can't.
We know
the
that,
whole
like,
point of that is like sometimes you can't prove your innocence.
Yeah, sometimes you can't.
I mean,
but
you know what I'm trying to say? Like,
yeah,
that's why.
Most of the time, I mean, it just depends on how you prepare the case.
Yeah.
The way I prepare a case, like my client is not testifying unless he absolutely has to.
Yeah, exactly.
Right? And I think that in a way, we have to start thinking about the criminal justice system as a different type of beast than the outside world, right? Because I think that when people come to a trial, they think in a way that this is the way it has to be, like the real world. But you, in essence, when you are in there, you have to let them know that this is not how it goes.
Right. I mean,
and this is not how it goes because you should not prove yourself innocent because of the system. Right. The system and everything is against you. Right. So if they're the ones bringing the charges, they have to tell and show and make sure they have the right person. That's who their job is.
Right. In this little legal world.
Exactly.
I agree. Like, so, like in Eugene's example or hypothetical, I don't know, was it
It's a hypo, and I've
Was
heard
it you?
before.
And-
It's a hypo. I've heard
Baby
it
G.
before. I've heard it before. It's a good hypo, you know.
And not hypo, like now you put your client on the stand or you put on a case. There's not really much
Why?
to
Yeah.
put. Like he's just gonna
Why?
say, "I didn't do it."
Right.
And
That's all he's
then
gonna say because he doesn't know how it got done.
that's it.
Yeah.
He doesn't even know the dog did. it.
That's what I'm telling you.
Yeah,
then-
and
but
to a
then-
certain extent, to a certain extent, you could almost make an innocent person sound guilty when their excuses don't sound reasonable.
Yes.
Because when you're
Right.
sitting there going,
I made the bed.
I made the
I
bed,
made
it. Well,
like,
and that-
you
that's-
just sound, but okay, but what, you know what the parent knows, you know what the jury knows? The bed wasn't,
Yeah.
a bed was not found
Right.
made.
But
You're
that's
not-
what-
Yeah, exactly.
So there's a dead person in his house. Yeah, I didn't. But I guess the question, it becomes a thing where it's like, how effective is just screaming to a jury, "I didn't kill the person"?
But that's what I mean. Like
Right.
that's why you know. For example, let's say you care about that. You tackle that voir dire. You go, can you tell me why a person who is innocent wouldn't testify?
Yeah.
Mhm.
And they will tell you. I mean, you can kind of guide them. You know, they're
Yeah,
nervous.
sometimes
They're just no good in front of people.
Mhm.
You know, I, as a defense attorney, tell you, look, they haven't done their job. Your job, you don't need to do anything because of your Fifth Amendment. And, you know, I'm sure you guys will get to that at some point, but like,
And-
you know, like
and,
it's,
and then like imagine like in that situation where like the stuff you say like mimic or like common
Yeah.
scheme like something what if
Well,
the
that might be
last two
before that,
incidents of him not making the bed come in
Yeah.
and now it's like
Yeah.
so he's definitely going to be found guilty in that situation
Well, that's
right
the concern. Yeah.
Yeah.
that's I mean but like it's more likely than
Exactly.
not because that's what that stuff does
you have to understand
in
that,
that
you know, the
situation.
system as a whole, it was built of, you know, I rather a guilty person goes free than, you know, 100 people, you know, that.
that's
you know,
what it's supposed
that's
to
what
be
it's supposed to be,
Yeah.
but it's not.
But it's
That's
I
not
think
how
you
it
should
is.
finish that sentence, right?
Yeah.
You'd
Suffice
rather
sentence.
1,000 guilty,
No, guilty-
people go free than one innocent person get convicted.
Yes.
Basically.
and it's,
Because there's a
that's-
greater
that's-
injustice in a society
Yes.
by
But that's
having
not
an
how it
innocent
is.
person be convicted and sentenced to a crime.
And I
they
think that was the
committed.
idea behind it, but that's not really how it is.
Our system is built on the premise that if you're arrested, you're guilty of something, right? We give police officers a lot of leeway where they're not viewed as making mistakes, as a society. Just
That's
my
true.
opinion.
No,
This
it's
is
true.
my
You're
opinion.
completely
We
telling the
like
truth
we
like that.
live in a society where we believe police officers.
We give a little deference.
We give them more deference, although, and again, this is in the legal world, a judge is going to instruct you that just because someone takes a stand in a badge, in a uniform, and is a police officer, doesn't mean that they're more credible or less credible than someone who's a layperson, right? We instruct the juries on that, but in reality, when you have people come in, whatever rank police officer they are, whether they're a captain, a sergeant, whatever,
In uniform with a
in
badge.
uniform with a badge, and they say they saw something and they did this and that, and according to protocol, they do this and that, they're going to be given more credibility than if the defense calls another witness, maybe a 13-year-old kid who's just walking from school and happened to see something and is like, oh yeah, that guy didn't do anything. That's just the facts. That's just the way it is.
I
That's
think
just the world we live in.
You're right.
You
And
know?
I think it's because of the world that we live in, and we give a lot of deference to authority.
We do.
We do. From when we're little.
Society does. Not me.
I'm talking about we as a
Joking.
society.
Yes.
When
Alright.
you're misbehaving in
So-
preschool or something, like you
Let's-
say, like,
So now,
Yeah,
if, as a defense attorney, right? If you're gonna do an opening, what are the things you're hammering home?
Reasonable doubt, baby.
yeah,
Reasonable doubt.
that, I'm with Ev, right? Like
Reasonable
you
doubt.
do the principles of law.
Right.
That's what you do.
It's hard
you,
to
you,
like.
you go into what they're going to hear a little bit.
Mhm.
And for most of the opening statement, you go into the principles of law because what repetition is the key to success. And they will
Right.
hear time and time and time again, reasonable doubt, reasonable doubt, reasonable doubt, and it will get in their ear what reasonable doubt is.
And what is reasonable doubt?
Nobody fucking knows. Low quality evidence as well as the lack of evidence, and what I say is any doubt, but they don't think it's any doubt. It's any doubt that can come from low quality evidence as well, and lack of evidence. That's really defined in New York.
I don't have a
It's
blanket
hard.
statement for
It's hard.
reasonable doubt.
It's hard.
It kind of gets molded based on the case, and then I kind of mold it based on what the case is, and I'd say that's reasonable doubt if you don't have these elements.
That makes
So
sense.
Mhm.
that's reasonable. That's reasonable.
fact.
Yeah.
Yep. If it's a case where it's like misidentification, and you know, there's no 911 call with any description.
Correct.
Miss
You know,
ID
where is that? You know, that's reasonable doubt.
Yeah,
you
Miss
know,
ID is
something
good.
like
Miss ID
that.
is good for us.
All right, so let's get into actual laying out evidence of a trial.
Mhm.
But something I realized we missed was conceptually, right? A prosecutor's gonna have to prove their case beyond a reasonable doubt.
Mhm.
But what that means in itself, so before we get into like their case in chief, I want you to just take a couple of seconds to lay out the concept that depending on what you're charged with will affect the elements that they would have to prove beyond a reasonable doubt. Can you?
What do you mean by that?
So, for example, like an assault case, right? You're gonna have to prove injuries.
Oh
you
yeah,
have to prove
like I mean, it
intent.
just depends. Yeah, it depends on the element of the crime.
Yeah, it depends.
Right,
on
it depends
yes.
on the crime and on the penal law, you know, depending on, for the penal law, you know, obviously is the law that governs all the penal offenses, you know, when you break the law, it's right there, stop laughing. I know
How old are
you,
you? How old are you?
yeah, how old are you?
You
How
know
old
what?
are you,
I've
bro?
never heard it been phrased that way.
The penal law?
No, the way you phrased it.
Oh, you know,
Continue.
with an
Penal
accent, you
law.
want an accent?
He said all the penal
The
offenses.
penal law, PL, subsection, section, whatever. That's what it is.
That,
That's where
all,
all the
all I wanted the audience to understand is that depending on the case,
yeah, there's different elements.
proving the case beyond a reasonable doubt changes, right?
Yeah.
Like they would have to prove that there were actual injuries.
Like in an assault, you gotta prove, you know that there's an injury. In a DWI, you have to prove that you were driving over the influence and limit. That's what you're trying to say. Yeah, there's different
Well,
elements.
DWI, you would have to prove that you were actually operating a vehicle,
yeah.
and while you were operating it, you were under the influence,
Yeah.
right?
There's
a difference between
difference.
being drunk in a car and operating a car. And
Yeah.
this affects all the elements.
Yeah, you're
All
right.
right. So
So I mean, they have to prove their case differently based on the charges that they bring.
exactly.